Right. Well, hello and good morning, and welcome to our June Employment Club. This is our second employment club that we've done this year. So, just to start with some housekeeping points for everyone, I'll come to all the explanation in a second. So, the session today is going to last about an hour. So, we'll try and make sure we finish at 11 because I know you've given up time today to be here. We'll try and keep a few minutes at the end for some questions and answers as well. So as you can see that on a slide there in the box. Thanks so much if you submitted a question to us already. We'll try and say get to all of those at the end. If there's any we don't get to, we will contact you afterwards with an answer by email. Also, just a quick plea from us. There's a brief feedback form which pops up, I think, when you exit the webinar at the end. It's always hugely helpful to us if you can take a few seconds to fill that in. We do go through each one. So if you can do that, that'll be massively appreciated. The session will be recorded, and what we'll do is we will send you a copy of that recording with a copy of the slides afterwards, so you can then go through it all again at your leisure if you're a real glutton for punishment. So you'll have those and they'll be circulated. Hopefully the questions feature should be in the top right of your screen. You can click on the right hand arrow and submit your question as you go along, and you can do that during the webinar. And don't worry, those questions are all anonymous, so please do that as you go. If you can't see the questions feature at the moment, click on the panel options button in the bottom right, which I think is 3 white dots. The questions feature will be an option at the top, and if you click that once, it should open. So hopefully that will work. We will be running a couple of polls during the talk today. And you should see the polls appear in the right-hand panel on your screen there. And when we launch a poll, we'll tell you, and then you've only got 30 seconds to fill your answer, so you'll have to be quick to answer the poll. And to get started now, we'll just do a quick practice poll just so everyone can see how that works. So hopefully you'll see that in your right-hand panel right now. So we've got the challenging question is what are your summer holiday plans going to be for this year? And you can see the answers there from I'm not having one through to I'm expecting to spend my holiday in a queue at the airport. So you can submit your answers to that now and we'll keep that poll open for 30 seconds. Okay, I think we've got the results there. So it tells me the poll's ended. So the most common answer at 45% was I'm having a foreign holiday. So that's good news, and hopefully all the queues at the airports will have died down by then. So that's how the polls work. So there's only a couple as we go along. So now the speakers today are going to be me. I'm Tim Woodward. And my colleague Emily Cox, and we're both members of the employment group here at Womble Bond Dickinson. Emily's going to be looking at some interesting recent decisions, some interesting recent cases, and also what's in the pipeline in employment law over the coming months. So some horizon scanning for Emily. That'll be the second section of the talk. The first section will be for me, and I'm going to be looking at, I suppose, how we handle grievances. Saying we'll kick that section off right now. So if I'll click on the slide, say there you go, dealing with grievances. Okay, in terms of grievances, you might say, why are we going to be looking at grievances today? Why does it matter? Well, one reason is we're seeing a lot more work coming into us in relation to grievances. Now, I don't know if there's a particular reason for that. May well be that with return to the workplace, that perhaps there's a bit more friction now between employers and employees, that they're in the same space. So that could be leading to that. But we've also been asked to do a lot more work in terms of carrying out investigations ourselves on behalf of clients, so in appeals or grievances or disciplinaries. So again, that's an interesting trend. But there are some wider reasons. I think Acas published a report last year in 2021, which was called Costs of Workplace Conflict in the UK. They said that the annual cost of all workplace conflict in the UK was £28.5 billion was the cost to the economy. They also found there were about 375,000 formal grievances every year. It's not informal, that's just formal. And their estimate was that each one of those grievances cost in management time about 951 quid. So just short of £1,000 in management time. That doesn't include advisors' fees, legal fees, or anyone else's fees. That's just the management time. So in terms of the economic cost for us as a nation, just formal grievances would cost £356 million per annum. So what we're looking at really is where you can take steps to deal with grievances early and deal with them effectively, that can both protect the employment relationship, but also hopefully save a lot of time and money going forward. So in terms of what we'll be looking at the Acas Code of Practice and Guide first, and you can see that's the first slide on the screen there. We'll also be looking at running an effective investigation, dealing with headaches or tricky issues that arise in grievances, holding an effective grievance hearing, and then finishing off with conducting appeals. So they're the main topic areas that I'm going to cover. So as we said, the first one there is the Acas Code of Practice and Guide. And we've put on the slide there some key points about the Code of Practice and the Acas Guide. And I'll look at now why they are important when you're dealing with a grievance. So in terms of a quick overview of the code, first point is it's not law. It's a statutory code of practice. So it's not legislation. And it does set out the key principles. It's quite a short document. It's only a couple of pages. The key principles for dealing with a grievance in the workplace. And that applies to both the employer and the employee, although it is fair to say that the requirements on the employee are pretty minimal. So it does land mostly on the employer. And why it matters is that employment tribunals are required to take the code into account when they consider if an employer has acted reasonably in dealing with a grievance or not. And it's also relevant, we'll see in a second, as to how you calculate the compensation that might be given if someone succeeds in a claim. And that can be very significant as well. The guide is a sort of companion piece document that goes with the code. That's a bigger document. It has lots of illustrations and examples and practical guidance for employers in dealing with the grievance using the code. So it sort of complements the code. Really good document, well worth taking into account. In terms of a grievance then, the guide itself defines a grievance as a concern, a problem or complaint that employees raise with their employers. So a grievance is very widely defined, and as you can see, pretty much covers any issue or complaint that's going to be made in the workplace. And what are the key points that are set out in the Acas code? Well, the employee has to let or should let the employer know about the nature of the grievance in writing. So that's an employee requirement. The employer is required under the code to hold a meeting with the employee to discuss that grievance as soon as it can after receiving the grievance from the employee. The employer has to allow the employee to be accompanied at that grievance meeting, either by a TU rep, trade union rep, or by a colleague. The employer then has to decide on the appropriate action flowing on from that grievance, the outcome, if you like. And if the employee doesn't like that outcome, the employee should be able to raise an appeal. So they're almost the key things that the code sets out. So again, it's fairly simplistic. I said the guide is more of an explanatory document, but it does throw a couple of interesting things up. So for example, employees should consider mediation to try and resolve grievances if they haven't managed to deal with it informally. And also employers should really train both managers, but also employee reps on how to deal with grievances effectively. So what are the consequences of not following that Acas code of practice? Well, as I said, it's not law, so it's not legislation. There's no freestanding claim that you can pursue at a tribunal. You can't go to the tribunal just because the employer hasn't followed that code of practice. But as we've also said, the tribunal has to take that code of practice into account when it assesses if the employer has acted reasonably. And if someone hasn't followed the code, it's also relevant to how the award might be calculated. So if you don't follow the code, the tribunal can adjust the award up or down by up to 25%. So if the employer doesn't follow the code, it can increase the award to a successful claimant by up to 25%. So if someone's pursuing an unfair dismissal complaint, for example, and part of that is that they lodged a grievance, and that grievance wasn't dealt with under the code, this could inflate the compensation paid out by the employer by 25%. So, a very significant difference. As I said, it does apply to employees as well, but they very rarely fall foul of the code because it's fairly simple for the employee. What claims, I suppose, could spring from failing to adhere to the code properly? Well, if you don't handle a grievance properly from an employee and you don't follow the code, that's likely to be seen or could be seen as a breach of the implied term of mutual trust and confidence that exists between employer and employee. That could mean that someone perhaps resigns ultimately and says, you breached that implied term, I'm going to resign and potentially pursue a constructive unfair dismissal claim at the tribunal. It could also be a discrimination allegation as well, because an employee could say, well, the investigation was too narrow or the decision was inconsistent. And I believe that's because I have a protected characteristic because of my sex, because of my race, because of a disability. So that could feed into a claim as well. And also, as we've got on the slide there, don't forget your internal documents. Most employers are going to have a disciplinary and grievance policy. So don't forget to check that grievance policy. And also, if you are going to deviate from your grievance policy in any way, agree it with the individual and agree it at the outset if you can. And then get something down evidentially to show that you've both agreed to change the approach. So, for example, if you're going to use a third-party investigator, which we'll look at later, and that's not catered for in your grievance policy, get that agreed with the individual, get something down in writing to show that both sides agreed to do that. Okay, that's the code. Now, as I said, we're going to look at running an effective investigation as well. And as you can see on the slide there, we've got some of the objectives of the investigation on the left, and then some issues that we'll look at now in this talk on the right. I'm going to start with another plug for Acas because they have a really good document which is called A Guide to Conducting Workplace Investigations. Pretty chunky, can be a bit off-putting, but really well written, very thorough, lots of useful examples. So again, I'd always recommend having a look at that if you've got time when you do run an investigation, because it's really helpful. As I said, we've got the key objectives of the investigation there on the screen. So, if you like, the first one, deciding if there's a case to answer. I suppose in a grievance context, that's deciding if there's merit in the grievance complaints that have been made by the employees. So that's almost the fundamental of the investigation. Make sure you treat everyone fairly and impartially when you're carrying out the investigation. And I'll come back to fairness in a second. Gather evidence from all sides. So don't just look at one particular viewpoint, either the employers or even the employees. Look at both sides of the potential argument. Make sure your report is a good guide for the decision maker, because quite often there will be someone doing the investigation and perhaps a separate individual will be making the decision. You want to make sure that the investigation report is a great basis for them to make that decision. And also, hopefully, the thoroughness of the investigation and the report will help avoid tribunal claims and also avoid unreasonable delays. So if you want to look at some of the key issues that are important here, one is always see if you can resolve it informally. That's usually the first stage in your grievance policy, and it will be the quickest, simplest, and cheapest method of resolving an issue if you possibly can. Won't always be possible, but sometimes it will. And don't make the assumption that the employee won't go for an informal resolution, because employees aren't usually keen on going through a grievance process anyway, and therefore they might find it attractive if some recommendations and changes can be agreed quickly and simply, and you don't need to go through the formal process. If you do have to go through the formal grievance process, then I just say really plan your investigation meticulously, because it's really important that you, I suppose, know the time frame that you're going to be dealing with, and you've got the component parts in place. So make sure you know the issues that you're going to have to investigate. If you've got a long rambling grievance document, agree with the employee the particular complaints or issues that you're going to look into. Boil them down so everyone knows where they stand. Work out what documents and correspondence and text messages you're going to need to get hold of, and how you're going to get hold of those as the investigator. So again, make sure you know what you need to ask for, what you need to see. Plan out which people you need to interview as witnesses. so you know who you're going to have to speak to and what diary time you're going to need. Work out how long all of this stuff will take, and don't underestimate it. It's very easy to underestimate the amount of time and effort that will be involved in the investigation. So don't underestimate the time, and don't give unrealistic expectations on the time frame. And also, start with your report format. If you know what the report format's going to be, you can do your work so you know you can put it into that report simply and straightforwardly when you've carried out the investigation. I mentioned fairness earlier on. So, in terms of conduct the investigation fairly, I always think that means really trying to be as objective as possible and not falling into what you might call like the confirmation bias trap. So don't come at the investigation with a preformed idea of where you're going to get to and then look for evidence to back that up. You've got to look on both sides, for and against the complaint, and make sure it's objective. Also, don't forget there's no legal right for an employee to have someone to accompany them at, say, a witness interview session or even an interview session with a person who might have brought the grievance complaint. There is a legal requirement to let someone have, for example, a colleague attend or a T-Europe attend the grievance meeting that's mentioned in the code, but not for these interviews. However, good practice would probably suggest you should allow that where you can, because it just looks better if a tribunal looks back at it. People can be very nervous in these situations, and having a colleague or a rep there will normally help that. So I'll just go on to the next slide. Oh, so this is running the effective investigation, again, a continuation of that. So one of the points on there, the first bullet, is investigations are more and more commonly challenged now, we find. And that's particularly the case where you've got a very high profile or very serious type of complaint, and maybe even something that involves some criminal aspects as well, where it's at that level, people tend to scrutinize the investigation very carefully and challenge it. One challenge we see quite regularly is about the robustness of the investigation. So in other words, did we get all of the evidence? And now, and it's been in the news with the government quite a lot recently, where organizations are using instant messaging and text messaging and WhatsApp messaging for work purposes more and more commonly, particularly because this stuff is done from phones more and more commonly. It gets much harder to locate those documents and that correspondence that you need, particularly if they're on personal devices. I know we've dealt with a grievance recently where we had a real problem in getting text messages from work mobile phones. We had to get everyone to hand them in. We had to send them off to the IT team. They had to download the messages. And we had weeks of correspondence because the employee still wouldn't accept we'd got every message from those mobile telephones. And that really caused a huge delay. So it is that kind of problem. You're also going to get data protection challenges as well. And that's usually about the fact that personal data will be processed when an investigation is carried out. And the issues there can be particularly more difficult if it involves, that special category data, that sort of health data, for example, which is pretty common, or data involving race or whatever it might be. And then you can get people complaining to the ICO, to the Information Commissioner, about this type of problem. So again, that's becoming more common as well. And there are also issues to keep in mind when you're using, or if you decide to use an independent investigator. As I said at the start of the talk, this is something that we've done quite a lot of recently when we've been asked to come in and operate as an independent investigator. It's fine, but there are things to keep in mind. One is make sure the terms of reference for the investigator are very clear. They're coming in as a third party. So make sure you map that out and potentially agree it with the person who's raised the grievance as well, so that everyone knows what the investigator will be looking at. So that's important. Have a communication strategy. Who will liaise with that third party investigator internally? Better to have one person doing it, and also to be quite careful in what you say in correspondence with the investigator. Make sure you know who's going to be responsible for the security of documents you might hand over to a third-party investigator, in terms of cyber security. Who's going to make sure that they are not leaking out? Also, who's going to be responsible for data protection issues in relation to those documents? Is it going to be the investigator, or will it still be, the employer? So if you get a subject access request, who will deal with that in terms of pulling that information together? And also, is there any legal privilege in terms of communication with the investigator? Because the short answer is there usually isn't. If it's the HR team or an operational manager liaising with the investigator, that's not going to be privileged. And like I said about the communication strategy, that can cause problems. We've had issues on cases where some fairly candid correspondence has gone backwards and forwards with the investigator, which ultimately has undermined, our case when we've come to a tribunal. So all of that needs to be borne in mind, but it is a good solution sometimes. Okay, I'll go on to the next one. I said we'd also be looking at some difficult issues, some tricky issues in handling grievances, and that's what we're looking at now on this slide. So to kick this one off, we've got a poll as well. So we've set out some of the difficult issues we're going to look at on the slide. Could you please respond to the poll and let me know which ones you've come across from that list, and we'll just have a look at that in 30 seconds. Okay, thanks very much for responding. That the poll has ended. I mean, interestingly, and perhaps not surprisingly, 60% of people who responded there have had more than one of those grievance issues. So, in a sense, that's not a surprise. Actually, 3% for grievances raised by former employees is perhaps a bit lower than I expected. I mean, we do see that quite regularly, but that might be a function of the fact that we often get involved if there's a case or a claim, sorry, and I suppose that might fit more commonly with grievances that can sometimes be raised after the event as well. So, yeah, well, it's good. I mean, that's positive in that we're going to be covering areas that people are fairly familiar with. Okay, so the first one we've got there is difficult complaints, and what do we mean by that? Well, here we're talking about perhaps serious allegations of bullying or harassment or discrimination, um, things that are very significant and very distressing, both for the person who's bringing the grievance, but also for the person or persons accused of that wrongdoing. Obviously, it's going to be a grievance because it's a complaint, but also it's likely to fall under other policies you might have as well. So if it's that sort of bullying or harassment type complaint, make sure you check your disciplinary process. Make sure you check your equal opportunities or equality policies. Make sure you check your safe work policies or your anti-bullying policies, just to ensure that you know where you might be going under those policies as well as the grievance, when that becomes relevant. So, keep that in mind as well. Where it's a very serious complaint that might involve, say, risk to employees, so risk to either the person bringing the complaint or someone who's been accused, you're going to have to think about suspension or even agreeing that someone will remain out of the workplace, even though this isn't a disciplinary matter at this stage, it's a grievance. But it can be quite common in very serious complaints that you decide that a suspension or certainly a voluntary agreement to remain away while you investigate is relevant. Clearly, if it's upheld in any way, shape, or form, it's very likely to lead to disciplinary action. So as we said, be ready for that next step as well, because the grievance isn't a disciplinary process, but you will be moving into that if it's upheld. And if it's very serious, there could also be police involvement. And that could bring its own challenges, and we deal with that quite regularly as well. You'll have to think about whether you need to pause your grievance investigation while the police do their work, and also whether the police are making requests and requirements or placing requirements on you that are quite difficult to deal with or that jar with your employment obligations. In my experience, and I've got one at the moment, the police don't always have a good grasp of your duties as an employer and quite often can tell people to exclude someone or dismiss someone and they don't really have the oversight as to what that means or what ramifications that could have. You don't have to do what the police tell you in that kind of circumstance, although you should clearly try and cooperate where you possibly can. But it's one that's usually important to take advice on. Witnesses wanting to remain anonymous or reluctant witnesses, again, a pretty common issue on a grievance where someone is prepared to give evidence, but they don't want to be identified. it's obviously a big disadvantage to the person accused of the wrongdoing. And that's because it's harder to challenge the evidence if you don't know the identity of the witness involved. The Acas guide says you should only use anonymized witness evidence in really exceptional cases. That might be where there's a fear of reprisal, physical threats, things like that, where, the employee really is genuinely worried about giving evidence. And if you do it, what the guide suggests is you should interview the person normally, prepare a full witness statement for that individual, and then redact the bits that identify the person so that you've always got a record of the full evidence, in the background. I'd also say don't guarantee anonymity as well to people, even if they are a reluctant witness, and you might, redact it to start with. Because if this goes ahead to an appeal and then potentially to a tribunal claim, they may not be able to remain anonymous. They may, but they may not. So don't guarantee to someone that they can remain anonymous almost whatever happens. Maybe just deal with it stage by stage. I want to jump to overlapping disciplinary and grievance issues next on that bullet. And that's because it's quite common for, I suppose, employees to submit grievances if they are being investigated on a disciplinary basis. And that can be cynically done for tactical reasons. They might put in a grievance when the hearing's about to take place or at some particular point in that process chain. And the Acas code on this says that, well, yes, you can pause your disciplinary process while you deal with the grievance. But more importantly, it also says that where those disciplinary and grievance issues are linked, maybe stemming from the same facts, you can deal with them concurrently, maybe having a grievance and a disciplinary hearing scheduled for the same day. So that doesn't waste time. So that's also really important to keep in mind, that you can run them at the same time. We also mentioned grievances raised by former employees as well on there, which is the code itself, the Acas code, doesn't require employers to deal with grievances lodged by former employees, by ex-employees. But there are some things that are worth keeping in mind. One is it might resolve something before it becomes a case or a claim. So just because someone has left employment doesn't mean they're not going to put in a tribunal claim. So it might tackle something initially, but also it might make you look more reasonable to a tribunal if there is a claim and they look back on what's happened. Also, there has been a case very recently, a slightly concerning one, where a 25% uplift was granted to the successful claimant on the basis the employer didn't follow the Acas code and dealing with the grievance, but the grievance was lodged after the employment ended. Now, the employer quite sensibly appealed this, but interestingly, the EAT didn't uphold the appeal and they actually agreed with the tribunal. So I think now more than ever, there is real merit in dealing with a grievance that's been lodged by a former employee. Perhaps even if you decide you're going to adjust the process a little to make it more efficient or more straightforward, but it might still be very, very well worth dealing with it. Okay, I'll go on to the next slide. Okay, this is about holding an effective hearing. So these are issues that can arise with the hearing itself. And again, there's some pretty common ones we've put on the bullets that we're going to look at. So the first one there is, what are you going to do if the employee doesn't attend because they've become absent with sickness or illness? Firstly, keep in mind that the Acas code says that employees should make every effort to attend the hearing, as should their companions. So that's quite a high bar. You should make every effort to attend the hearing. But if the employee still goes off with illness, perhaps stress and anxiety before a hearing, and they get a fit note from a GP, then look, as the employee, you're probably going to have to postpone that and rearrange it. But if you then get into a position where there's a delay, a significant delay, then the employer has to try and balance the need to deal with the grievance promptly and also the fairness of allowing employees to attend a grievance meeting or, a witness interview as well. But remember, this isn't a disciplinary process. This is a grievance process. So if the employee who's brought the complaint is absent with illness, it doesn't mean you can't carry out the rest of the investigation if you know what you're doing and what you're looking for. So it doesn't necessarily mean you'll be losing time. But clearly, you'll want to give the employee who's made the complaint and perhaps the person who's accused the chance to attend a meeting or to at least attend a witness statement session so you get their proper input. So it's always going to be a balance. And we'd always say, do your best to find a way. You know, those remote meetings, the team meetings, the Zoom calls are much more common now. That's a way of dealing with it. You know, allowing a family member to attend to provide moral support. Or even just dealing with it in writing. There are all ways that can get round someone who perhaps is not well enough to work but could still take part. Maybe you get an occupational health report as well with a specific question about whether the person is medically unable to participate, because normally that's quite a high bar to get over. So you can easily be not well enough to work, but still be well enough to take part in the process. But ultimately, if the delays are getting too long or the employee refuses to engage, you can hold it in their absence. Just make sure you've got a good record, you know, of what's being dealt with. Um, Remote hearings, we're all familiar with these now. Obviously, this webinar is kind of testimony to that. You know, post-pandemic, remote hearings are more attractive than ever, probably. I mean, people would still say that face-to-face is going to be better, but I think that distinction is certainly now very tight, and that might change over time anyway. Acas issued guidance during the pandemic about how employers can deal with remote hearings for grievances and disciplinaries. You know, and that involved talking to the employee involved and their companion to make sure that any concerns could be addressed. I mean, there are practical problems. I mean, it's not, you know, always plain sailing. You know, you've got to check everyone's got the right equipment. What's the broadband like? Can everyone take part properly? Is everyone confident enough to use the equipment? And that can be age related. You know, is there a disability issue? Does someone have a visual impairment, for example, that could be a problem in using a remote device? Can you properly ask questions of the witnesses? You know, a companion's going to be able to attend. And are you going to record the meeting? And therefore, have you got everyone's consent to that? We then got requests to call witnesses. So the Acas code for disciplinary processes says that employees should be able to call witnesses, but it's silent on the grievance side. But I think the better view is still that if an employee does want to call a witness in relation to the grievance, well, consider it. And I think you should allow it where you possibly can, as long as the person is relevant. If the witness isn't relevant to what's going on, then absolutely you should be rejecting that. But if not, consider it where you can. Also, requests for copies of witness statements, usually by the person who's been accused of the wrongdoing in the grievance. I would say again, yes, provide copies of witness statements to the person who's accused of the wrongdoing. You know, that may well become a disciplinary issue anyway. I think they should have the ability to see the evidence against them and the ability to put into their own statement or answering questions, you know, their version of events. Again, if it's anonymity that's a problem, we've talked about redacting it already, and I won't go through that again. And the last one on the slide there is covert recordings, a very, very common problem now. I've been doing this a long time. 15, 20 years ago, this wasn't an issue because to have the equipment to covertly record was either expensive or it was clunky. It was quite hard to do. So it didn't happen very often. Now anyone with a smartphone can do it. We see this problem all the time, people leaving it in a coat pocket or in a bag or sticking it on the desk and recording the meeting covertly and then using that against you later on. Make sure you check your policies. If that says that you can't record it, which would normally be the case, make sure you tell people at the start of the meeting. You can do practical things like asking everyone in the meeting to put their mobile phones on the table or to one side, you know, turned off. If you're going to have deliberations over the decision, don't let a person leave their coat or their bag or their phone in the room while you do it, because we've had that problem on a case before where people have recorded the discussion before the decision is reached. And obviously all of that stuff is much more difficult on a remote basis. So, you know, if it's a Zoom or a team meeting, then clearly it's hard to stop someone recording that, although that doesn't mean that information is necessarily admissible. Oh, back on. Let me go back on that. Apologies. Right, last one from me about conducting the appeal. So the far end of this process, the Acas code says, yes, you should allow an employee to appeal if they're not satisfied with the grievance outcome. The guide gives lots of useful information about conducting an appeal in a grievance situation. So again, have a look at both of those. Check your own policies and procedures. That's critical. See what your grievance policy says about an appeal and make sure you stick with that. Ideally, it's going to be a new impartial manager of the right level of seniority to hear the appeal and make a decision. Also, is it going to be a review or rehearing? In short, a review means reviewing the decision made already against the grounds of appeal. So looking at the challenge in the appeal and then reviewing what's been done to see if you're satisfied the decision should stand. A rehearing is basically hearing all the evidence again and making a new decision. That's much less common because it takes a lot more time and it's a lot more involved. Are there any situations when that might be relevant? Well, for example, if the allegation in the appeal is that the person who made the decision was wholly biased, had an axe to grind, nothing could be relied on, you might take the view that you want a new manager to hear all of the evidence again and come to a decision. But other than that, a review is the most common one. Um, Finishing off just with some practical pointers on appeals. Look, an appeal by the individual should be in writing and should set out the grounds for appeal. So make sure you get the employee to do that. Don't let them just say, I want to appeal. Get them to set out the grounds properly in writing for you to work on. Make sure the appeal, if you can, is heard by someone more senior to the original decision maker who's not been involved in the matter already. And I know that can be a problem sometimes in terms of just sheer numbers of people. Make sure the person has time to prepare. So give them proper notice of the appeal hearing and give them a chance to, prepare for that properly. The employee does have a right to bring in a companion to this under the code. So, that's a legal right. You're going to assess the grounds of appeal in coming to your conclusion and make a decision as to whether that is rejected, upheld, or even upheld in part. Make sure you let the person put their case in that appeal hearing. And if they want to call a witness again, allow that if the witness is relevant. If the appeal manager does carry out further investigation, then make sure you give copies of that evidence to the individual so they can see that new evidence as well. And then the code says that the outcome of that appeal should be provided in writing without unreasonable delay. And that's the end of my section on dealing with grievances. So I can hand over to Emily now for the next section.
Thank you, Tim. So I'm going to discuss a couple of important cases that have been reported since our last webinar in March, and then I'll have a look at some developments that are currently on the horizon. So the first one that we are going to look at is the Guardian News and Media Limited and Razanov and another. So this is an employment appeal tribunal one. So most hearings in the Employment Tribunal are held in public, which means that the press and members of the public are free to attend, and journalists can report on those proceedings. So this is in keeping with the common law principle of open justice, which ensures there is a public scrutiny on the way court decides cases and enables the public to understand how the justice system works and why decisions are made. But does it require a party to a claim to disclose copies of documents to a journalist? So the facts of this case are Mr. Razanov was employed by EFG Private Bank Limited, which is a Swiss bank. He brought a whistleblowing claim in the employment tribunal, alleging that the bank had subjected him to detriment and had dismissed him because he had made protected disclosures. The parties agreed that the names of the bank's clients would be redacted, is essentially blanked out from the paperwork, and an anonymity order was made in relation to the names of 4 individuals. So a selection of those documents that would identify one of the bank's clients was included in a confidential annex to that hearing bundle. Now, journalists attended the hearing and were able to inspect copies of the witness statements. The Employment Tribunal rejected Mr. Razanov's claim. 4 months after the end of the hearing, a Guardian journalist actually wrote to the Employment Tribunal asking for copies of various Employment Tribunal documents, which included pleadings, skeleton arguments, witness statements, and all documents that essentially were referred to in the Employment Tribunal's judgment. He explained that the Employment Tribunal decision raised matters of legitimate public interest, including possible breaches of anti-money laundering legislation. By this time, however, the Employment Tribunal had destroyed almost all documents it held in the case, which meant that if disclosure was ordered, the bank would have to retrieve the documents from its records. The bank objected to the request, but Mr. Razanov did not. So the decision at the Employment Appeal Tribunal was that they granted the application. So it found that the journalist had put forward proper journalistic reasons for the application, which included enabling him to better understand the matters dealt with in the judgment and helping to ensure fair and accurate reporting. So the public interest in the underlying subject matter of the proceedings weighed in favour of ordering disclosure of those documents by the bank to the Guardian. The inconvenience to the bank was minor, especially if they provided the documents electronically. So, what does this mean for employers? This is an important development in the principle of open justice in the context of employment tribunal claims. Employers defending employment tribunal claims should be aware that witness statements and other sensitive employment tribunal documents may be accessible to the media and therefore the public after a hearing has been concluded. So I think we do actually have time for this poll. So if we run another poll on this. So essentially, what do you think of the Employment Appeal Tribunal's decision? Do you think journalists should be able to attend employment tribunal hearings and access documents? Or do you think we should ban journalists from the employment tribunal altogether? What are your thoughts on that? Right, so poll has ended. Drum roll. Right. So we've gone for majority, 60% have gone for journalists should be able to attend employment tribunal hearings, but not have access to employment tribunal documents. Interesting. So not a complete ban for journalists then. That's good news. So the next one that I will be covering is the Rogers and Leaders Laser Cutting Limited, another employment appeal tribunal decision. So the background for this one, it was first reported as the first employment appeal tribunal decision in a COVID-19 case. The background is that the Employment Rights Act states that an employee is unfairly dismissed if the reason for dismissal is that in circumstances of danger, which the employee reasonably believed to be serious and imminent, and which he could not reasonably have expected to avert, left or refused to return to his place of work. So the facts in this one are quite interesting. So Mr. Rogers started employment with Leeds Laser Cutting on 14th of June 2019 as a laser operator. The business operated out of a large warehouse and there were normally 5 employees on site at any one time. A risk assessment was carried out by an external consultant on site at the beginning of the pandemic, which, oh gosh, that was mid-March 2020. So this recommended social distancing, sanitizing surfaces, and staggering sort of start, finish, lunch, break time. Recommendations were already in place. Now, on the 29th of March 2020, Mr. Rogers emailed his line manager stating that he had no alternative but to stay off work until the pandemic ceased because he had a child with sickle cell disease who would be very ill if he caught the virus, as well as a 7-month-old baby who could have underlying health problems. Mr. Rogers obtained a self-isolation note from the NHS 111 service covering 28th of March to 3rd of April. On the 30th of March, he drove a friend to hospital. He also worked in a pub during the first lockdown. He made no further effort to contact his employer, and his employer did not contact him until the 24th of April when it sent him his P45. So Mr. Rogers brought a claim for automatic unfair dismissal on health and safety grounds. So he didn't have 2 years service, so he essentially couldn't bring an ordinary unfair dismissal claim. So the decision by the Employment Appeal Tribunal, well, they rejected the claim. So although the pandemic created at least some circumstances of danger at workplace and sort of elsewhere, Mr. Rogers did not reasonably believe that there were circumstances of danger that were serious and imminent at work or at large that prevented him from returning to his place of work. There were a number of facts that contradicted Mr. Rogers' contention that serious and imminent circumstances of danger prevented him returning to the workplace, which included the workplace was large and few people worked at it. He remained at work from the date of the lockdown when it was announced, that was the 23rd of March, until his normal time on the 27th of March. He could generally maintain social distancing at work. He didn't ask for a mask when it was available. He also drove a friend to hospital when he was meant to be self-isolating, and he worked in a pub during the lockdown. So the Employment Appeal Tribunal found that there were steps he could have reasonably have taken to avert the danger, such as wearing a mask, socially distancing, sanitizing, or washing his hands. So essentially, this is a really helpful decision for employers. He took if they took steps to comply with the government guidance on working safely, so carried out a risk assessment and implied with its recommendations, so claims like this one are unlikely to succeed. It is interesting that the Employment Appeal Tribunal have put emphasis on the fact that Mr. Rogers had not just failed to take reasonable steps to avert the danger, he had actually exposed himself to additional risks outside of the workplace. So although the pandemic seems to be coming to an end, fingers crossed, we are still seeing cases concerning COVID-19 in the Employment Tribunal. This is probably likely due to there is a backlog in the Employment Tribunal, so we may end up seeing some more Employment Appeal Tribunal decisions. We are aware that employers are grappling with the challenges around employees who are reluctant to return to the workplace after a pandemic for various reasons, where employees are alleging health and safety related reasons for staying at home. So hopefully this decision helps you. So the next slide we're going to is it going to work? There we go. So our pipeline. So as you can see, this slide shows the developments that are due to take place for the rest of the year. So I think some of the most interesting ones are that BEIS will publish guidance for employees on the on voluntary ethnicity pay reporting this summer. So while ethnicity pay reporting will not be mandatory, employers who publish their ethnicity pay figures will have to publish a diagnosis and action plan setting out why disparities exist and what they will do to address them. So that's this summer. And I believe we also have a poll to run on ethnicity pay reports. So does your organisation publish ethnicity pay reports? This will be very interesting to see. Right, let's have a look at the results. Okay, so we have 11% that have said yes, absolutely fantastic to hear. And we have no at 55% and don't know at 32%. Interesting. So it'll be interesting to see actually after this whether you consider looking at ethnicity pay reporting. Also in the pipeline, from the 1st of July, fit notes can be issued by medical professionals other than doctors. Now, this is in order to reduce the GP's workload. So registered nurses, occupational therapists, pharmacists and physiotherapists will also be able to sign for them in England, Wales and Scotland. This applies to fit notes issued for the purposes of SSP and Social Security claims. Technically, an employer could insist on a fit note being signed by a doctor for occupational sick pay purposes, but GPs are unlikely to be happy about being asked to sign a fit note if the employee could ask someone else to do it, essentially. Your sickness absence policy may need to be updated as a result of this change, so always worth just double checking those policies. And then we've also got the COVID-19 concession on UK right to work checks. So this ends in September. So while it is in force, employees can ask a new recruit to send them the scans and photos of their identity documents and set up a video call to see the recruit with the original documents. And employees must still record the date they made the check and mark it as a adjusted check undertaken on sort of insert date due to COVID-19. So from the 1st of October, however, it's essentially employers will have to go back to face-to-face and physical document checks. So the government has stated that retrospective checks in relation to employees who started work while the concession was in place will not have to be made. So some interesting bits and pieces on the horizon there. And then we've also got some pipeline elements that we don't yet have a date. And I think one of the most important ones there is the employment bill. So you'll all know the Queen's speech was delivered by the Prince of Wales at the state opening of Parliament on the 10th of May. We've been expecting an employment bill for some time, but there's still no sign of it. I believe it was first mentioned in the Queen's speech in December 2019. And according to the TUC, the government has promised it on at least 20 occasions since then. So it was meant to deal with various matters such as protection from redundancy for pregnant women and new parents, a default right to flexible working, new safeguards for the gig economy and 0-hour workers, ensuring restaurants hand over all service charges and tips to staff, and the creation of a single enforcement body for employment rights. So essentially, we will have to wait and see if that materialises. And also, we have a data reform bill potentially floating out there in the ether. So this will replace EU rules on data protection laws, meaning that GDPR and the Data Protection Act are likely to be repealed or amended. So the government has stated this will reduce the burdens on business and enable public bodies to share data to essentially improve the delivery of services. So they intend to move from a tick box exercise to focusing on privacy outcomes. So we shall find out what that means essentially. So we are now on the Q&A session. Tim, have you
Yes.
spotted any Q&As
Yeah.
that?
I have. I've managed to respond to one by typing. I said we got a few minutes here, so we can try and get into some of those that have come through. As I said, if we won't get to all of them, but what we will try and do is pick up the questions that have come in and ping you out an email response as well, just so everyone can see that. So if I just jump on the first one there, which I think looks like is from Jane, which was, we refer to producing a report and a report and a separate person to decide the outcome. I think that's a separate investigation and separate decision maker. And then you said, would you consider it appropriate for the investigator to be the decision maker and then have a different person for the appeal? I think the short answer to that is, if we were talking about a disciplinary process, you'd be saying, if you can possibly avoid the same person being the investigator and decision maker, please do so, because it just avoids that allegation that it was somehow tainted. Grievances are slightly different. It is more common that in a grievance situation, someone will look into it and come to a decision. And I don't think the code in any way kind of outlaws that, although it's quite common for the grievance process or policy to say it will be separate individuals. So I think the short answer is, look, I don't think that's inappropriate. Check your own policy. If you can use separate people, all the better. But I think for a grievance rather than disciplinary, you probably can, get away with using the same person to check it and give the answer. We've got one there from Karen about, can the police stop us from proceeding with an internal process when there's a criminal element to it? We've proposed excluding the criminal elements and proceeding with the remainder. Well, I think that, again, the answer to that one is the police don't really have any direct jurisdiction in terms of telling you what to do and for your internal employment process. I'd always cooperate with them where you possibly can, just for all sorts of reasons. But as I said, you need to look after your employment process yourself, because you as the employer will face the ramifications from that, not the police. So look, if it's I've had petty scam type or theft type issues where the police have specifically asked us not to investigate because they were trying to effectively catch someone in the act. And we, of course, agreed to that. I've had the same kind of thing with sort of internal fraud. But I think when it's not that sort of tipping off process, I would say if you can keep aside the criminal elements, yes. And if that satisfies the police, yes. If they've got a very persuasive reason, then I would say, look, consider it. But ultimately, you don't have to do that. People often say it will put the individual in a position where they'll kind of criminalize themselves by the answers in the internal employment process. My view of that is I don't agree. If you're telling the truth, you're telling the truth. You're not criminalizing yourself by answering the questions. But if the individual has a criminal lawyer, they'll often tell them not to take part in your internal process anyway. So you might have to deal with it in their absence. I'll try and squeeze in a couple more very quickly. Okay, if we receive more than one informal grievance from a team of staff about their manager's conduct and behaviour, do they all have to be processed under the grievance procedure? Sorry, I've got the screen there. Or, sorry, get rid of that one. Sorry, I've got another question that's popped up in front of it, and I need to try and get rid of it. Yeah. Do they all have to be processed in the grievance procedure, or can the disciplinary procedure be instigated if the organisation is concerned about bullying and harassment? Good question. I mean, the short answer is it is an allegation, effectively, in the grievance. The normal approach would be to probably deal with the grievance. When it's come from a group of people, you can probably deal with it as a group grievance, so you don't necessarily have to do each one separately. You might be able to combine them into a group grievance with their grievance and consent. I think if you had a situation where it was very clear that you needed to get on with the disciplinary quickly, and I think that would probably be unusual, then I'd say, well, you could try and run them concurrently, but there is a risk in doing that because, of course, you could end up with different decisions at either end. So I think the first base is if you can deal with the grievance first, ideal, because then you'll either uphold the complaint or you won't, and that will feed into your disciplinary process. As I said, if there are real-time pressures and issues that won't be solved by suspensions, because of course you could suspend the manager while you look into the grievance and then deal with the disciplinary process. If the risks are sufficient, that might help you deal with it. I said if there's other pressing concerns, which mean you simply can't wait, you might have to take a decision that you're going to deal with it as a disciplinary matter and perhaps agree with the individuals that you won't deal with it as a grievance first. You will just move straight to the disciplinary process. I'll finish with with a very simple one. Will there be a recording of this sent out following the session? As I said at the start, there will be. You'll get a copy of the recording and also a copy of the slides. So I'll just try and squeeze in a couple of housekeeping points before we go, so I can release everyone at 11. Firstly, thanks for taking the time to join Emily and I today. We know it's giving up precious time during your working day. As I said, we've tried to answer some of the questions there. We will answer all of the questions that you've submitted. If you've got follow-up questions after the session, please don't hesitate to contact Emily or me. Our details are on the slide there. You will see a short feedback questionnaire pop up when you try and escape from the session. I said, if you can take a minute to fill that in, as I said, we do hugely appreciate that. We do review them all, and we do react to what we've seen on there. And I think all that leaves Emily and I to do is to wish you a good day and hope you enjoy the sunshine, and hopefully we'll see you on our next session. Thank you.
Thanks all.